Good afternoon, friends. And we wish probably some of them will not be joining the sessions of tomorrow and in between. Happy Holi in advance. Being the festivity season, we thought that let's bring more colors to the knowledge, and that too an electronic evidence, which is a very important facets for the purposes of a student of law and as well as the lawyers. Electronic evidence in the courtroom, a lawyer's manual written by Yuvraj Narvankar is already doing very well in this regard. So we thought, why not have insights in respect of electronic evidence courtroom, law and practice. During this session, Mr. Narvankar would be giving the key insights as usual, because he's already done his sessions and his one of the fortes is electronic evidence. We have received few questions and we will also take the questions live from the YouTube, Facebook, as well as on the chat. At the end of the session, the question will not be answered during the session itself. So do stay connected. And over to Yuvraj, and thank you for accepting our invite.
Thank you so much, Vikashji. I hope I am audible to everyone.
Yeah.
Thank you. It's always a pleasure to be on the dais of or on a virtual platform of Beyond Law. Last time I had spoken, I think now the Beyond Law has grown meets and bounds. And I wish all the best to Vikashji in this journey of knowledge, which is very close to my heart, and I think will be close to every heart of a lawyer who is always a student of law. So thanks for having me here back again. I must tell you one thing at the outset. We had thought of calling this session as Electronic Evidence Part 2. The reason of calling it as a Part 2 was because we earlier, those of you who do not know, we already had a Part 1. And we spoke of certain basics in Part 1. But then we thought of not calling it a Part 2 so that the people who are attending this for the first time should not feel left out. But let me assure to all my friends who were part of Part 1, or those of you who were not part of Part 1, that they will not feel left out, one, or there won't be much repetition. But I must indicate one thing with due apologies to all the persons who were part of first part, that I'll be repeating certain basic concepts, maybe in first 10 to 20 minutes as a short recap, because today's session will be majorly on the cross-examination and the practical aspects of the electronic evidence, will not be much on the theory. So to just begin with, first let us understand the whole concept of this electronic evidence from the standpoint of an evidence act. Because evidence, and I will request all of the participants to have this book with them, if at all, if it's possible, or they can open the mobile application or the PC, because what we will be discussing will have a lot to do with the bare text. Friends, the Evidence Act came to be enacted, as we all know, in the year 1872. Now, one gentleman called James Stephen enacted this, I would say, a very beautiful piece of legislation, which is relevant even after, I think, almost 1.5 centuries, so to say. And we still don't feel a need of a major amendments. And I think there lies a success of an act like a Evidence Act. Now, with this, you must understand one thing. When this code was written way back in the year 1872, there was obviously these all electronic gazettes and all these applications were not even in the foresight. But now, very interesting part comes in. If you look at the definition of the word document, which is you will find in section 2 of the Evidence Act, the word document is defined very interestingly. The word document is defined is that any matter expressed on any substance by any means for the purposes of recording something. Please mind the words. Any matter recorded on any substance by any means. I would like to give you a very interesting example, which one of the author had given. I think it's a book by one author called as Vepa Sarthi. He gives a very some analogous example, that assume for a moment that one farmer wants to defame his neighbor. He has two options, either to go out and shout publicly about how stupid the neighbor is. He chooses another way. He writes on his buffalo that my neighbor is an idiot person. And he leaves that buffalo in a town to roam around. That buffalo roams around in a town, and you know that everyone comes to know that this and this gentleman, this neighbor is an idiot person. Now the defamation suit is filed by obviously the person who was agreed with all this defamation. Now the primary document in this case will be a buffalo, because this squarely falls within the definition of a document, anything written on any substance by any means for the purposes of recording something. And therefore this buffalo becomes a primary evidence or document, so to say. Now take an example. Now this is, we are talking of a centuries back scenario. Come to today's time. Those of you who have seen the CD being written upon, you will see a ray of light doing some scratch on a platform of a CD. The surface, there is something being written, something being etched by that laser jet. Now what is that? It is what we call as a writing of a CD. Now again, will this not be something, any matter written on any substance by any means? It will be. And here it becomes very relevant to appreciate the definition of document, that the definition of a document in its current form is capable of taking care from buffalo to the present day compact disc, because the definition is so widely worded that the legislators in the year 2000, when they enacted the Information Technology Act, they did not feel it necessary to amend the definition of document for the reason that I told you, that the word definition itself has been defined quite extensively. You will just excuse me for a minute.
One minute.
Sorry, there was some mic issue with my system. Yes. So the definition of the word document has, that's the beauty of the definition, that it is capable of taking the care of something that was in existence a century back and is still relevant. Let's go a step ahead. If you look at the definition of evidence, the evidence is of two types. First is an oral evidence, another is a documentary evidence. If you look at the definition of evidence as defined again back in the Evidence Act, it says that the documents, including electronic records produced for the inspection of the court, is what is the definition of evidence or documentary evidence, so to say. Now you must understand one thing. What we will be discussing today will be about admissibility of electronic record. Now, what do I mean by admissibility of electronic record? And why is it relevant for today's topic? Friends, when we will be discussing the topic of cross-examination, the cross-examination as we will be discussing will be pertaining to an admissibility of electronic record and not the probative value of an electronic record. And let me explain both of these concepts for my friends. Please understand that the evidence is of three. The evidence basically has three limbs. First is called an admissibility. Second is called as a relevancy. And third one is called as a probative value of an evidence. Now, what is an admissibility? Let me just explain in brief. Let's take an example, a very simple example, that I had a discussion with my client in my office about a case. Next day, my client is under examination, under cross-examination. The other side lawyer asks him a simple question. Mr. Can you tell the court what was the discussion that you had with your lawyer yesterday? Now, is this something that is relevant to a case? It might be, because the client must have spoken to me about my case. So it's relevant. But is it admissible? Obviously, it is not, because that's a privileged communication under Section 126 of the Evidence Act. So we get our first example of relevant but inadmissible. Take a second example where the witness under the cross-examination is asked. Suppose it's a case about development of a project at Kolhapur or at Pune. And the witness is asked, can you tell the court how many projects have you done across Mumbai? Technically, is the question admissible? It is admissible because there is nothing in law, at least nothing in the Evidence Act, that prohibits asking of such a question. It's neither scandalous nor privileged. But is it relevant? Technically not, because the project in question is a project of Pune. So we get another example where the question is admissible but irrelevant. And let me now deal with the third limb of the Evidence Act. And this is all for my junior friends, which I had spoken about even in my last lecture, but I'm just repeating as I told you, just to brush up. Third limb is a probative value of an evidence. Now, what do we mean by probative value of an evidence? Suppose if a person claims that he had seen person A murdering person B in a broad daylight. he comes to a court, he's cited as an eyewitness and he's under examination. Now assume the same scenario and he says, yes, I saw that person being murdered and this happened before me. Now take an example, just change the time of the day. This doesn't happen in a broad daylight, but this happens in a midnight when there are no street lights. Now the witness is the same. He claims to be an eyewitness to murder of B, but the probative value of evidence will be substantially lower because you cannot believe a testimony of a person who is claiming to have seen that in the pitch of a midnight and when there were no street lights. So the testimony remains the same, witness remains the same, incidence remains the same, but the probative value of the evidence substantially goes down. So please appreciate, my friends, that today what we will be discussing will be only admissibility of electronic record, because so far as the relevancy is concerned, exactly same rules apply to electronic evidence as it applies to documentary evidence. This is something very important that you must remember in the course of a trial. We got section 65A and B on our statute books just for the sake of admissibility of electronic record. We did not get it on our statute books for the purposes of relevancy of electronic record. That still is being dealt by our old Evidence Act. Now, where do we get the chapter of relevancy? I think all of you will be aware that the Evidence Act is divided into 11 chapters. Chapter 2 of it deals with the relevancy of facts. And section 5 very categorically says that evidence can be given only of the facts which are relevant and not of any other fact. You also read this with section 136, which you will find in chapter 10 of the Evidence Act. Section 136 is a very important section to which I in fact called a gateway to the Evidence Act. Because section 136 tells me that if a person proposes to give evidence of any fact, the court will ask him as to in what manner that fact will be relevant if it is proved. And only if the court is satisfied that yes, the fact will be relevant if it is proved, then the court shall admit the evidence, not otherwise. So friends, please remember that the only evidence that can go on record is a relevant evidence. So the admissibility technically comes later, because the admissibility of the documentary evidence is what you get in chapter 5 of the Evidence Act, and relevance is what you get in chapter 2 of the Evidence Act. So the legislative intent was this, that first relevancy has to be seen. And this is the concept that is reinforced by section 136 when it says that only relevant evidence shall be admissible. So what comes first is a relevancy, and what comes thereafter is the admissibility. Unfortunately, in the course of day-to-day practice, you will see the judges repeatedly saying that let the evidence first be recorded and we will check the relevancy thereafter. Let this first question go on record. But sorry to say that this is not what the legislature ever intended. You cannot allow anything and everything to go on record unless the court finds it explicitly relevant. So this is something that we all must keep in mind for the times to come. Now let us look at the scheme of the Act. We will be talking of chapter 5 of the Evidence Act, which is where section 65A and section 65B, about which we are going to talk at length today, are situated. Now, have you ever wondered that what would have been the fate of the electronic evidences had this chapter been not there, or had these sections been not there? Just imagine of the regime pre-2000 when we did not have these sections in a statute book. Can you tell me what was a section that was being invoked? The story is very interesting. If you look at the whole structure, chapter 4 talks of oral evidence, section 59 and 60. 59 says that the content, everything can be proved by oral evidence except contents of a document. Let's not go into it. That's not the chapter for today's discussion. Section 60 says it must be a direct evidence. It can't be hearsay evidence. Again, it's not relevant for today's purpose. Interesting journey begins from section 61. 61 tells me that the contents of a document can be proved by primary and secondary evidence. So far, so good. Section 62 then comes into play. And section 62 defines what is a primary evidence, which says the document itself produced for the inspection of the court is a primary evidence. Section 63 tells me what is a secondary evidence. And if you see one of the clause of section 63, it says the copy is made from the original by mechanical process. Please remember this. I will not go into other limbs of it, certified copies, copies compared with, no. We are only concerned with the relevant clause, which is copies made by mechanical process, which in itself assures accuracy thereof. Is the clause we are concerned with today. Now please come to section 64, which says that you must give the primary evidence except in the cases hereinafter mentioned, mentioned, and that is what section 65 talks of, in what cases secondary evidence will be admissible. Section 65, let us again do away with rest of the clauses. When the original is in possession and power of someone, when the original is lost and destroyed, we are not concerned. What we are concerned with is clause D. When the original is such that it is not easily movable, you can give the secondary evidence of the contents of it. Now just imagine, you would remember that earlier time we had these huge computers and desktops. Obviously, these were not the things which we could easily move to the court. Even laptop, for that matter, we cannot easily put that as an exhibit in the court. It's something that is not easily movable. Therefore, before 2000, this was a section 63 read with section 65D, which was being invoked by the proponents of electronic evidence to say and to tell the court that, my lords, this is something that is not easily movable in the court. These are the copies made by the mechanical process, which itself ensures the accuracy thereof. Therefore, please admit this document into evidence. So these were the two entry points for the electronic evidence before we had these sections 65A and 65B in our statute books. 10 more minutes and we will cover the history of this section 65A and B. Now, please remember that in 2005 around, we got a judgment of Navjot Sandhu where the Supreme Court said that section 65A that is newly brought uses the word that the electronic evidence may be proved in accordance with section 65B. Supreme Court said that the word used is maybe, and therefore it is not compulsive on you to only resort to section 65A and B. Let us go back to the pre-2000 regime and let us prove these electronic evidences as we are doing it before. And therefore, 65A and 65B were done away with virtually in the case of Navjot Sandhu. It almost took a decade for the Supreme Court to revisit this law in the judgment of P.V. Anwar. In P.V. Anwar, Supreme Court said, sorry, what you read is section 65A, please read section 65B, and the word it begins with is the non-obstante clause. Non-obstante clause means notwithstanding anything. It means that section 65A and 65B will prevail over all other earlier sections. So to say 61, 62, 63, 64 and 65. Therefore, please do not look at those sections. You will be only looking at 65A and 65B. And therefore, out went the judgment of Navjot Sandhu and the ratio that came with it. And we fall back to the regime that 65A and 65B provided. And this view was reaffirmed, as you all will be aware of, in the judgment of Arjun Panditrao Khotkar. Now, I will not elaborate this very elaborately because, as I told you, I have already spoken at length on these two judgments in my earlier webinar. But this was just to show you the journey with which this all began and where we are today. So the today's scenario is this, that with the non-obstante clause of section 65B, you cannot look at anything that is before 65A and 65B. Okay. So now let us come to section 65B. 65A, as I told you, very specifically says that electronic evidence may be proved in accordance with 65B. Now this may will be read as a shall because of the judgment of Arjun Panditrao Khotkar. Now there is a very beautiful judgment that probably the Bombay lawyers might be aware of. This is a Jaimin Jewelry Exports judgment. Now in this judgment, the Bombay High Court has very beautifully distinguished the concept of admissibility and the relevancy of 65B. That how 65B only deals with the admissibility and not the relevancy. And there the Honorable Bombay High Court had said that, look here, if you provide section 65B certificate along with some electronic evidence, it does not mean that what you say in that electronic record is correct and true. All it says that that document is admissible into evidence, it can be exhibited in evidence. It does not prove the truth and correctness of the contents. Let me pause here again for a minute for my junior colleagues, and let me tell you the difference between the contents of a document and truth of contents of a document. Suppose if A writes an email to B calling B an idiot person, B files a suit in the court of law of defamation. B obviously puts that email into the record for exhibit. The document is exhibited. Now, does that mean it's along with 65B? That email is filed along with 65B. Document is exhibited in evidence under order 13 of CPC. It's a civil suit for defamation. Let's assume for a minute. Does that mean that what A says in his email is true and correct? Does that mean that B is actually an idiot person? It can't be, because then the entire foundation for the suit will go. It will only mean that A had indeed sent an email to B calling B an idiot person, and therefore the document is marked into evidence because it is accompanied with section 65B certificate. So please remember, the contents of a document and truth of contents of a document are two completely distinct concepts. Please do not confuse them too when you are dealing with 65B certificate. Even if you produce 65B certificate, your client or you will have to independently prove the truth and veracity of the contents. It is not taken care of by the 65B certificate. Now let us start decoding section 65B, and then we will begin our journey into the cross-examination aspects of electronic record. Now, if you look at the definition, it is very interesting. 65B, the whole concept. It says that notwithstanding anything contained in this act, those of you who have a bare act ready, please, you can have a look at it. I'll be only covering the major aspects of it as I go along. Electronic evidence is not separately defined. As I told you, it is again, we have to fall back on the definition of document. All that you only can have about electronic evidence is all contained in this section 65B, and therefore Justice Nariman called this as a complete code in itself. So please mind the words of 65B very carefully. It says, notwithstanding anything contained in this act, any information contained in an electronic record, printed on a paper, or copied, recorded in optical or magnetic media produced by a computer shall be admissible into the evidence and shall be deemed to be a document. Please let us pause here for a minute and we will break this definition. Notwithstanding, I have already told you what is the purport of this. It will now prevail over everything. Please remember here again that electronic record is not defined. It says that information contained in an electronic record printed on a paper. So suppose even if the email is printed on a paper, that will constitute an electronic record. Or copied, stored, or recorded in optical or magnetic media. What is optical media is a CD. What is magnetic media is a hard drive. Now, these electronic records. But let me tell you that the pen drive, flash drive is magnetic media. It is what is called as a flash drive or a flash storage. Therefore, technically speaking, 65B does not cover pen drive or does not cover flash drive. But as I had told in my last talk, that we have to apply the mischief rule of interpretation, and we have to take even pen drive into the compass or in the ambit of section 65B. Therefore, any information contained in an electronic record, stored, copied, or recorded in magnetic or optical media produced by a computer. Please let us pause here for a minute and let me tell you some very important concept. What is produced by a computer? Suppose if I type out a petition on my laptop and if I print it, is it not something produced by a computer? Technically it is, because printer is what from which the whole print is coming out, right? Or the data is fed into my laptop and then it has come out through a printer. So is it not something produced by a computer? It is. Does that mean that every petition that I am filing in the High Court or every plaint that you are filing in a trial court will require 65B? It won't. It will lead to a very absurd situation, because the computers have become omnipresent. You will have them for each and every purpose. Therefore, the word produce needs to be given a very constructive meaning. And there is a judgment of R versus WAD, R versus WAD. This is from the UK Court of Law, United Kingdom's King's Bench, where the word produced has been given certain connotations. The court has said that word produced means that there must be some process that must have been done by the computer on the document. It must have been subjected to certain process by the computer. If the computer is merely used as a means of storage or is used just as a means for input, then that does not mean produced by a computer. Exactly same thing happened in this case, that when I'm putting my petition, when I'm typing out something on the screen, I'm just putting in the information. Technically, there is no arithmetic or analytical process that is happening. And therefore, the word produce has to be given a very constructive meaning. However, if I put an image into my laptop and if I do something, if I crop it, or even if I put an image, ultimately the image acquisition source is a camera. When the camera lenses capture an object, What it is capturing is the light that falls on object, the reflection of a light that falls on object. And there is a process happening behind the lens. And therefore that falls within the definition of produced by a computer. So please remember this important distinction of produced and processed. What the legislature meant is processed by a computer. Technically produced cannot be taken in a literal fashion. It will lead to a very bizarre consequence. Okay, let's move a little bit. Produced by a computer shall be deemed to be a document. Please understand why deemed to be a document, because the definition of document, as we just saw, is not amended, and therefore the deeming fiction is incorporated. The legislature has said that, look here, these all things, optical, magnetic, paper, shall be deemed to be document and shall be admissible into evidence. Admissible, underline the word, admissible into the evidence without further proof or production of the original, as a proof of the contents of which only direct evidence could have been admissible. Let us bifurcate all these words. Shall be deemed to be a document and shall be admissible into evidence without further proof. Let me answer a question that is being asked to me by many of the attendees in most of my seminars, that whenever I give an email in the court of law, whenever I give a transcript in the court of law, is it necessary for me to produce the original device along with it? Technically, no. Because the words of the section itself say that the moment you comply with 65B, now what are those compliances? We will see that in a bit. But the section itself gives me an excuse, or section itself gives me a leeway of not producing anything more. Please underline the word without further proof or production of the original. This is a disjunctive. These both will have to be read independently. I don't need to do anything further. The burden of proof on my shoulders with the electronic evidence stands discharged the moment I give section 65B certificate. I don't need to do anything further, or nor am I expected to produce the original in the court of law. Let me here again tell you all, most of you are under impression that if I produce the original in the court of law, I don't need to give 65B certificate. In fact, this is the view that is also endorsed by Justice Nariman in the judgment of Arjun Pandit Rao. But let me tell you all that with due respect, and this aspect I have elaborated in my book as well, that there is no concept of original and copy thereof in the world of electronic evidence. There is no concept of primary and secondary. These are the concepts that exclusively belong to the older generation of paper documents. In the world of electronic evidence, everything is secondary, everything is a copy. Let me just tell you in a minute. For example, if I'm typing out something in my laptop, if the light goes off, if the battery is down, my data will not go anywhere. If I put the charging cable back into my laptop, what I will see on the screen is the saved version of the Microsoft Word. You must have all experienced this. How does it happen? Because while I was typing it out, the computer, without me knowing, made numerous copies thereof. So which copy of it is original, you can't ever say. So there is no concept of original and secondary in the world of electronic evidence. So therefore, please remove this understanding once for all, that we can dispense with 65B if the original is produced in the court of law. 65B is must. Now let us move ahead. When will that be admissible and when will that be deemed to be a document? It says, provided the conditions in section 65B are complied with. Now, what are those conditions is very important. The first condition, now please look at 65B2. We are done with 65B1. It says the input must have been fed into the computer in the ordinary course of the business for the purposes of activities regularly carried on by the person with lawful control. Let me just explain to you what does this mean. It means that the output that you are trying to produce in the court of law must have been produced by a computer which is used regularly. Why does it matter? I'll give you an example from my own experience. There was a case where a CCTV evidence was sought to be produced as evidence. You all are aware that the CCTV cameras have the time which is running on its screen, a live time, a real time. When we examined the piece of evidence, I found that the timeline on the CCTV was incorrect. And when we dug into it, we found to our surprise something very interesting. The reason was this, that the CCTV was not in a working condition for more than 2 years. Just a week before the incidents happened, the CCTV was repaired and it was put to work. What happened because of it, I'll tell you. There is a clock which is called as a BIOS clock, BIOS, which is an inbuilt in even in your computer, even in your laptop, even in every device that you handle. What does it do? It maintains the system time. So the real world time is different and the system time is different. You will have to synchronize them too so as to get the real time. But if you do not use a device for a couple of years or for a couple of months, depending on a device, the BIOS battery completely drains out. That leads to resetting of time and date. So suppose even if it's 4 p.m. in my clock, the reset time might show 1 or 12:30 or 10:30. And you all will appreciate that in a case like murder, where the timeline is of a most crucial importance, particularly in the cases where the last scene with the deceased kind of cases, how important the timeline is. In these kind of cases, this can pose a great jeopardy to the accused. And therefore, it says that the device must have been used regularly. And this is the first condition of 65B. You cannot take this definition at its face value. You will have to dig deep into it to understand the purport of it. Second, please look at the definition, the second clause of it. It says the computer output as derived was regularly fed into the system. That is the second condition. Now, what do we mean by regularly fed into the system? I'll give you another example from one of my arbitration. In one of the cases, we had a voluminous record produced by a computer. And I asked the witness that, can you really vouch for the correctness of this? He said, yes, I can. I asked him a question that you have filed 65B. Can you tell the court or tell the tribunal that the data as derived was regularly fed into the system in the ordinary course of the activities? He thought for a while. He said, yes, it was regularly fed in the ordinary course of activities. I said, can you please produce the logs of this computer? He was reluctant, but ultimately we prevailed on the tribunal to summon the logs of the computer. And to our surprise, and also the surprise of the tribunal, what we found was very shocking. Just a day before the production of the evidence, that entire data was fed into the system. Now, will you really call this data regularly fed into the system in the ordinary course of the activities? Technically, you cannot call this data as regularly fed into the system in the ordinary course of the activities, because this is what is called as creation of evidence. You cannot flood the system with the evidences when you become aware that I need to put that into the record. It has to be regularly fed in the ordinary course of the activities. These words are very important, because these are the exactly same words that you will find in section 32 of the Evidence Act, to which we also call as the business records exception in the US law. In the United States, this concept is known as a business records exception, that if the data is fed in the ordinary course of the activities, law generally presumes that the person will not regularly input the data which is false or fabricated. Therefore, the law attaches certain degree of authenticity, certain degree of reliability to the data which is ordinarily fed in the regular course. And therefore, this 65B specific, this part will have to be taken with always a pinch of salt. You will have to probe the witness. When was the data fed? If the witness is in the regular course, you can call upon the witness to produce the logs of a system. Let me just explain in a minute what is the logs. In my book, I have explained these technical aspects. I may not be able to that effectively explain all these concepts in this webinar, because that is more of a theory, where with the help of diagrams and some snapshots I have explained. But let me tell you that whenever a system is run, suppose for example, if you open your laptop, that is added as one of the entry in the log, even without you knowing it. When you open a file, that is entered as an entry in the log without you knowing it. Therefore, every action that you do reflects in a log, and therefore logs of a computer is something very important. Can you access the log yourself? You can. Again, the technical process involved I have elaborated in my book, but very difficult to explain on a screen. But let me tell you, even if you try yourself to access the logs of a computer, it's not very difficult. You can just search in the bar that you see at the bottom. You can just see the logs and you can access it. Even from the control panel, you can go there. Let's come to the third condition. And let me tell you here, I think this I have spoken in the last session, so I won't again elaborate much. But let me tell you, unfortunately, the condition that we just spoke of, that the data was regularly fed, is something that is not foolproof. Merely a regularity of the input cannot vouch for the correctness of the input. And last talk, I had given an example of a weight scale. Suppose if I am standing on a weight scale just to check my weight, and if the weight scale is already made at 5 kgs instead of 0 kgs, then my weight will be shown as plus 5 kgs every time I stand on the machine. So suppose if I'm standing on a machine every day in a month, the data is bound to be wrong. Therefore, the regularity of input does not matter. What matters is the correctness of the input. If the original value itself is plus 5, then mere me standing regularly on the machine will not make it any more accurate. Therefore, please understand the regularity of the input is not the only criteria. However, under the Evidence Act, unfortunately, so to say, only regularity has been focused, unduly focused, not the correctness. And therefore, in the UK now, you will find a section analogous to section 65B has been done away with. It is no longer in the statute books. Electronic evidence is treated at par with the documentary evidence, probably what was even, I think, anticipated by Mr. James Stephen. But now the UK does not follow the regime that we follow, because our system unduly emphasizes on the regularity of the input and not the correctness of the input. Please now come to the third requirement. Third requirement tells me that throughout the material part of the period, the computer was being used or operating properly. It means that the computer, if is malfunctioning or if is not working, if is not in working condition, that will affect the correctness of the system. I don't need to give you a separate example. I think the first example that I give you of CCTV, I think is good enough for you all to understand why the regular functioning of a computer is so important. You can ignore D, because D is almost like B and it doesn't require any specific illustration. Now, please understand, friends, that the document, this electronic record, let's revisit what we just said a few minutes back. Electronic record shall be deemed to be a document and shall be admissible into evidence after it complies with these technical conditions and one non-technical condition. Technical condition, as I told you, it must be functioning properly, it must be regularly fed. These are all technical conditions. There is one non-technical condition which I just want you to focus on. This non-technical condition is production of certificate, what we call as a 65B certificate. This certificate has to be given by the person who is in charge of the system, who is in charge of the device. It cannot be given by anyone else. Let me give you an example. Suppose if there is some incidents that happened in my office of theft, for example, and I file a complaint to the police officer. When I give the CCTV footage in the custody of police, it will be me who will be in charge of the system, and therefore I will have to give section 65B certificate. Suppose if the police officer send this footage to a forensic lab of theirs to analyze, and if they analyze it, then that 65B certificate will have to be given by the concerned forensic lab. I can't give for it. I can't do it for them. Nor can they vouch for the correctness of my system, nor can I vouch for the correctness of their analysis. There will be therefore two 65B certificates, which sounds little bizarre, but this is what the law is. And this is called as a concept of a contemporaneous certification, of which again I have spoken in the last talk. Contemporaneous certification and multiple certifications. These are the two concepts you will find in two judgments of the Madhya Pradesh High Court. One is a judgment of Sanju versus State of MP. It's a 2019 judgment of Madhya Pradesh High Court, where the courts have elaborated on this concept of contemporaneous certification and multiple certification. What is contemporaneous certification? The courts have said that suppose if the incidence of theft happens on, let's say, 10th of March, I cannot give a certificate in the month of, let's say, December. It has to be contemporaneous, because standing in December, I cannot vouch for the correctness of my system in the month of March. And therefore, the certificate has to be contemporaneous. Some of you might ask me a doubt that how will I anticipate that this footage will have to be used in the trial? I come to know only in the month of December that that's going to be a piece of evidence. So how am I expected to? Otherwise, it will be like every day I have to keep preparing 65B certificate just with the hope that I will have to use it in the future. Let me tell you that the courts have taken care of this contingency in their judgments. And I will earnestly request you to go through both of these judgments. First one is a Sanju versus State of MP. Another one is Kamal Patel versus Ram Kishore Dogne, again of the Madhya Pradesh High Court. The courts have said that no, if it is a case where you are not aware at that point of time that this is going to be a crucial piece of evidence, then obviously we are not insisting for a contemporaneous certification. However, if you are aware at that time that this is going to be used as a potential evidence in the court of law, then you must prepare a contemporaneous certificate. Let me give you a same example. When the theft happened in my office, I am not obviously aware, I was out of office. I was not aware that this footage is going to be of so much importance. So I cannot be saddled with the responsibility of making a contemporaneous certification or a live certification. But when the footage goes to police, when the police machinery is analyzing it, the forensic lab is analyzing it, they are surely aware that this is what we are doing for the purposes of proving in the court of law. They are saddled with the responsibility of making the contemporaneous certification. They obviously cannot throw up their hands and say, no, we were not aware that this. Obviously, they were aware. That was the reason the material was sent to them in the first place. So go through these two judgments, which are very important. Coming back to the point where we left off, it must be signed by the person who is in charge of the system. So suppose if it's a CDR, it has to be authenticated by the person who is in charge of that system of mobile company. It can't be the IO, it can't be anyone else, it can't be the PP's office, it can't be you, it can't be a complainant. It has to be the person who is authorized by that particular cellular company to do it. Now what he has to say, it is not required to be in specific form. Many of you have been asking me the formats of this 65B certificate, and I have said this even on last occasion that in my book I have given certain formats, but let me tell you that these are just illustrations. I have dealt with 65B of a CCTV evidence. How do you put 65B? Or of the emails, or of the CDRs. What are the ideal formats of 65B certificates? But let me tell you that you can also yourself prepare ideal format of 65B certificate. It is not it's rocket science. It will depend on case-to-case basis. You will have to only do 3 things in your certificate. First, you have to identify the electronic record. You have to identify the manner in which the electronic record is produced, and you have to identify the devices involved in the production of electronic record. For example, identify the electronic record. Let's take my case. The electronic record is CCTV footage. The manner in which it was produced, it was put up at this place. It was covering this much area. This was the make and machine time. This was the BIOS time. It was in sync with the real time. This is all you are going to say in 65B certificate, mind you. Then you will say this CCTV was handed over to police on so and so date, just to take care of the concept of chain of custody. I'll tell you in a minute about this very important concept. This was handed over to police on this and this date. Then the police took it for the further analysis. This is the end of your role. You are not supposed to say anything beyond what happened when you gave it to police. Now the ball goes in the court of police machinery. So you did what? You identified the electronic record. You identified the manner in which it was produced. You identified the devices involved in the production. That is all. And ultimately you say in that certificate that this information is true to my knowledge and belief. Though the word used is and, it can be only knowledge or belief. This is what Justice Nariman also says. It can't be both. I'll tell you why. For example, if it's my machine, it's in my knowledge that CCTV was working properly, correct? But if it's not in my knowledge, suppose if the PP's office or the public prosecutor's office has to give an, let's say, certification, then they can't vouch for my system. They can't have a personal knowledge of how well my system is working. So they will have to say in my belief. So it can be either knowledge or it can be belief. It can't be both. Though the word used is and, it should be technically or, is what even Justice Nariman says in his judgment. So this is what it is about, the electronic evidence. Now, friends, so many times it so happens that the person who is in charge of this system refuses to come to the court of law. He says, I am not going to come to the court of law. Let's take a case that theft happened in my office, but my CCTV does not record it. My neighbor lawyer's chamber is there. His CCTV records it. I go to him, I say, sir, please, I want 65B certificate. This is what has happened in my office. I would need your assistance. He says, sorry, I can't really help you. I am overtied. My hands are full. I can't really do all this. Sorry, I won't be able to do it. Now, technically speaking, 65B says that the certificate will have to be given by the person who is in charge of a system. Here, the in charge says, no, I am not coming. Then what do I do? Shafi Mohammad's case, I think around 2016 or somewhere, Supreme Court took note of this anomaly and said that in these kind of cases, 65B insistence can be dispensed with. You are excused from 65B compliance because you can't catch a hold of a person and bring him to the court. But in the judgment of Arjun Panditra of Kotkar, Justice Nariman differs. He says, even if he is not voluntarily ready to come to the court of law, you can use certain sections to summon him. And Shafi Mohammed is no more a good law. And he then technically overrules Shafi Mohammed, saying that it dilutes the impact of 65B. How do you call that lawyer, my neighbor lawyer, to the court of law? As an illustration, he gives 3 sections to us. Arjun Panditrao gives me 3 weapons. First is section 165 of Evidence Act. I think all my judges friend, the newly minted young judges will have to read this section 165 because I would call it a repository of powers. Section 165 of the Evidence Act says that a judge, in order to ascertain the truth or proof of a fact, can ask any question in any form, in any manner, to any witness, relevant or irrelevant, and the lawyer or his client will not be allowed to object to such question being asked, nor will they be allowed to cross-examine the witness for the answer that he gave. Just look at the extent of the powers that section 165 invests the court with. And Justice Nariman refers to this section that and says that, look, here we have a section which can require attendance of a person to the court of law. Then he refers to another section, which is section 311 of Code of Criminal Procedure, which again gives the equal power to summon any witness or examine any person at any stage. He again refers to section 91 again of CRPC, which gives a right to the court to summon any witness or anything in the court of law. And ultimately, Arjun Pandit Rao says that you can use all these sections to call the concerned witness to the court of law and procure 65B. So therefore, do not plead helplessness. You have these many sections. Though it is not mentioned, let me tell you, if I remember correctly, Order 16 Rule 6 of CPC also allows the court to call to summon any person to produce a document. This is so far as the civil trial is concerned, and 91 and 311 I just spoke about are so far as the criminal trial is concerned. And Evidence Act, as you are all aware, applies to both civil and criminal. Therefore, 165 will apply to both of it. But what happens to a case where, in spite of you doing your best, the witness does not turn up? There, Justice Nariman had said that then you can claim exemption from compliance with 65B. If you are running from pillar to post to get this certificate, and still if you are not getting it, which is precisely what happened, interestingly, in Arjun Pandit Rao case itself, Justice Nariman says, then you are excused from the performance, then you can claim an exemption because law does not compel the impossible. Is a very famous Latin maxim. And therefore, if it is impossible, then forget it. Then you can get the certificate, you can authenticate it, you can give it. And the burden then shifts on the other side to disprove it. Now, let me tell you how to cross-examine. But before that, let me also tell you, many a times it so happens that particularly in a family disputes, husband gets an access to wife's phone and gets certain crucial records and uses it against herself, let's say for proving, let's say, charges of adultery. What happens to these kind of cases? Now, let me tell you that these kind of illegally obtained electronic evidences are admissible in court of law. There are many judgments of the Honorable Apex Court and the High Courts, which say that the illegal evidences, illegally procured evidences, are per se not inadmissible. They are admissible, provided they should be relevant under Chapter 2 of the Evidence Act. What can you do as a counsel for the person whose right of privacy is affected? You can invoke Section 43 of the Information Technology Act. Section 43 says that if a person's resource like a computer or computer resource or any device is compromised, or if is accessed without his permission, then that person is entitled to damages. And I myself have dealt with many cases where the person's privacy was compromised in litigation. During the litigation, we have got, I wouldn't say exemplary, but sizable compensation because of breach of right to privacy. So technically, you cannot oppose the production of the evidence, but you can probably take a revenge, so to say, by resorting to other provisions of law. Uh, this not only entails into, mind you, civil remedy. Section 43 of the information technology talks of damages. So basically a civil remedy. It also contemplates a criminal remedy, which is section 66 and 66 of the Information Technology Act. So person will probably will have to face jail as well if he unauthorizedly accesses someone else's system. Therefore, this is a very drastic section. For 66 even there is a provision for obviously filing of a first information report, FIR, but you can also get damages, and the authority for getting the damages is called as an adjudicating authority, which you will again find in section 43 of the Information Technology Act. So just this is to give you now how do you draft the complaint, how you file a complaint, how you actually plead the facts, and what are the essential ingredients is something that I have elaborately explained in my book. There's a special chapter in my book which talks of how to deal with illegally obtained electronic evidences. In fact, there are few judgments to which I have made a reference to, where the high courts have said, going against this flow of judgments, the high courts have said, sorry, we will not look into this evidence because this is obtained by violating the person's right to privacy and right to personal integrity. You're all aware, after Justice Puttaswamy's judgment, the Honorable Apex Court's judgment in Justice Puttaswamy's case, now the right to privacy is held to be a fundamental right. So it cannot be so easily compromised. And therefore, the high courts have taken a view that we will not look into this evidence which is collected by violating someone else's right to personal integrity. But there are very few judgments to that effect, and majority of judgments are in favor of adducing the evidence or admitting the evidence. But as I told you, that these are the remedies that you can have. Now, at what stage do you have to give 65B? You can give it at any stage. This is what now the Supreme Court has said. 65B is a curable remedy. Even if you don't give it at the outset, you can give it at any stage of the trial. But you will have to give it before the document is marked into evidence. If you don't give it, the document cannot be marked into evidence. However, if by mistake or through inadvertence, you forget to object, as a counsel for the other side, if you forget to object to marking of a document or marking of an electronic record, though it is not accompanied by 65B, and if that electronic record is exhibited, then sorry, your doors are shut. There are judgments of the High Court and Supreme Court which say that if once the document is exhibited, there is no provision for de-exhibiting of a document. That is concept unknown to Indian Evidence Act. Once it is exhibited, you are supposed to have waived that objection. Therefore, you have to be on your toes, on your guard to see that no document which is purported to be electronic record goes into the evidence without 65B and without laying down the foundational requirements. So far as arbitration is concerned, Section 1 of the Evidence Act itself says it doesn't apply to arbitration. Section 19 of Arbitration Act also excludes Evidence Act. So you can't insist on technical compliance of 65B. But the technical, though it is not technically required in spirit, you must observe the spirit of Section 65B. Even in arbitral proceeding, you must lay down the foundation of authentic electronic record. Let me now on screen project a part of my book which is dealing with the how do you actually deal with the electronic records? How do you actually cross-examine the electronic record? I would just share my screen. Can you see it on a screen? I would just need some confirmation, maybe by Vikashji. Yeah. These are some of the illustrations I have given in my book, where I have actually dealt with real life cases. Suppose, for example, if I'm dealing with CCTV evidence, how can I cross-examine the witness? Suppose if I'm dealing with the email, how do I cross-examine the witness? If I'm dealing with the hard disk expert, how do I cross-examine the witness? And I will just refer to one or two examples just to give you a fair idea of how we have to approach the electronic evidence. Let us take the illustration number 8. I'll just read it out for you. Because is the screen, are the words legible?
No, fonts is small.
I will try to increase the font size. I'm not very sure if I'll be able. Is it now better?
Yeah, now better. You can still make it bigger. Yeah, now it's better.
A computer is apparently used by a person for making certain searches and downloading certain files. This information is used to corroborate the charge against the person. Take a case where the hard drive is seized by the police from the computer and the computer is not seized, only a hard drive is seized without assistance of a forensic expert and has been given to a forensic expert for analysis. Your client believes that some data is tampered or lost during its handling. Such destruction can be deliberate or inadvertent. If this charge is driven home, it would attract a penalty under 204. Now let us look at how we can cross-examine this proponent of an electronic record. Let me pause here for a minute and tell you what I mean. Suppose if your client is charged with a case like murder, and there is only a circumstantial evidence that your client was seen last with the deceased person, and therefore the charge is sought to be driven home, saying that this man was seen last with the deceased, and therefore this is the circumstantial evidence. And you feel, and your client tells me, no sir, I was with him for around 15 minutes and thereafter I left him. We were in a shopping mall doing shopping together. And if you check the CCTV footage, you can see me walking out much before the incidents occurred. There you feel and suspect that certain data is deliberately withheld, or certain data is omitted, or only selective data is produced. Then how do you cross-examine is something that we will just have a look. For example, there is a report and you will always see the word used, the summary of a report. You will ask the forensic expert, can you tell why have you used the word summary of the report? Because this report is supposed to be the summary. If this is the summary, then can you show where is the entire report? This is the only report that I have. Will it be correct to say that summary of the report cannot be prepared unless there is a full report? I'm very sure there won't be any answer to it. Or if he answers, have a follow-up question. Can you tell me what steps did the original hire? The expert will have to describe the methods. If they are not forensically sound, then the methods can be attacked. An attack on his expertise can also be launched. Did you prepare the hash values of the data before its acquisition? He might say yes, he might say no. Will it be then correct that you did not have any material to verify the hash value of the data post-processing? Yes. Could you see or notice during the forensic examination any data being overwritten or deleted? No, I did not see that. Did you look for it? I was not asked to. Could you have done that if you are asked? Yes, certainly. Is it possible that the data that was handed over to you for the forensic analysis was the selective data and not the entire one that was there on the hard disk? It is possible. Did you not install the original hard? No, I did not. Do you know who removed the hard disk from the computer? No, I don't. Are you aware of the steps taken by the person for removal of the hard drive? Not exactly. Will it be correct that every access made to a computer system would leave digital footprints and would lead to some alteration and creation of log files and the data would no longer be the same? Yes, to some extent. Did you notice any user account on any of the hard drive? Yes, I did. Can you tell me the reason for its non-mention in the report? Nothing specific as such. Did you check if the computer was password protected? No, I did not. And then friends, it goes and goes forth. Let me pause here for a minute and tell you that this is the case that I have actually taken from one of the real life case, where after the cross-examination, this was just the beginning of a cross-examination. Almost the questions run into, I would say, around 80 to 100 questions. At the end of the cross-examination, finally the court rejected that electronic record as inadmissible, because what the expert was given was only a hard drive that please Mr. examine this and give us the report. He did not make the hash value. Now what is the hash value? Let me pause here for a minute and tell you. Suppose if this is the hard drive, whenever this is given to me as an expert, first thing I have to do, not only as an expert, as a police officer also, what first thing I have to do is to make a hash value of this. Hash value means that it is a software that even if you Google, you will come to know, even you can calculate the hash value of any file. It may be a Word file, maybe Excel file, maybe an image file, maybe a hard drive. You can make a hash value. This hash value will be same if the data is not changed. So even if I change this data 100 times, if I make it from this iPhone to another iPhone to another iPhone to another iPhone, hash value will remain the same as long as the data is not changed. Even if one comma is changed in this data, the hash value will change. Therefore, it is very necessary for the investigating authorities to calculate the hash values whenever the data is acquired and make a note of it. And when the data finally reaches in the court of law, again hash value will have to be calculated, and both of them will have to be compared with each other so as to certify that the data has not changed. If the hash values are same, it means the data has not changed. One single comma changed, the entire hash value changes. It means the data is compromised. In the case that I just read out, the expert admitted, and this is from a real life, the expert admitted that I did not calculate the hash value when the hard drive arrived at my lab. I calculated the hash value after the data was processed. Technically, it will be of no use. It will, because the hash value at the time of at the inception is the most crucial. Otherwise, how else will you compare the hash value? Therefore, whenever the data changes the hand, hash value will have to be prepared. Let me give you an extreme example. The example that I just gave you from my office. If there is a theft, if I am handing over a data to the police, I technically will have to calculate the hash value. Police will have to calculate the hash value. Cyber forensic expert will have to calculate the hash value. And in an ideal scenario, in a classic scenario, in a textbook scenario, my hash value must match with the police hash value. They must match with the forensic expert's hash value. Unless this is not complete, the chain of custody is not complete. This is what is called as a chain of custody concept. So basically, thanks. There is a message about the contents of a book. No, the reason I was telling you that in the book, I have very elaborately detailed all these circumstances, because this is, I wouldn't call hyper technical, but this is semi technical. And therefore, the first chapter of my book I have written for my lawyer friends, because we are not very tech savvy. We are not very computer friendly. We still belong to a generation, or we still live in an era where our knowledge of computer is only limited to the basics: how to operate the phones, how to operate the laptops, how to operate the computers. Whenever we see very technical piece of electronic evidence, we get puzzled. Therefore, my entire first chapter of the book is on how to deal with the technical aspects, and it is written in as easy language as possible. And the feedbacks that I have received from the people is that the people have now gotten so much interest in the technical aspects that one of my colleague last week shared a case with me where they were planning to call a technical expert to cross-examine, and then after reading the chapter, he decided to go for a cross-examination himself. And the feedback that we had was tremendous, that he could very successfully cross-examine. We are awaiting for the award. We hope it will be good. But the point is that don't have a fear of the technical aspect. Technical aspects are easy to crack. Only problem is that we have got unnecessary, fear of this, because of we think it's a skeleton in the closet. No, it's not. Be comfortable with the technical terms. They are very easy to understand. I have tried my best to make it understand. Once you get good grip on the technical aspects, it's very easy to cross-examine the witness effectively. For example, let's take an example of an email. Email, you have to have a header of an email. Otherwise, you can't produce that email in the court of law. If you ever try, friends, you just try in Word, you can type an email. If you take a print of an email, it looks the same. If you type it out in the Word, MS Word, it looks the same. If the print is produced, how else will you identify that this is the Word form and this is the actual print? You can't. And therefore, header of an email is most important. Now, how to get the header of an email and how to analyze the header is again, wouldn't be able to explain this here. But I have tried to explain that in my book, that how to get the header, how to explain it. From the header of an email, you can know who has sent it, if it is the phishing email, if it's a duplicate email, from which geographical area that email has come, who has actually sent it. If it's a duplicate email, header is a repository of all this important information. It's very technical, but at the same time very easy if you apply your mind to it. Now let me come to a last part of today's session, and then in a couple of minutes we will have all these queries as well. Friends, please remember that you can always examine the expert in the court of law under section 45A of the Evidence Act. Now, can any expert come and depose? Technically, no, because section 45A very specifically says that that person must be certified lab under section 79A of the Evidence Act. If he is not certified, then he cannot come and depose under section 45A. Does it mean that all the doors are shut? No. If you look at section 45, you can call him under section 45, because section 45 allows you to call the witness to depose about any matter of a scientific nature. Ultimately, these are the matters of a scientific nature or of technical nature. Therefore, I think even if the doors of 45A are shut, if it is not notified under 79A, doors of section 45 are always open for you. You can always call a witness. Can you cross-examine him on the electronic record? You can, but please look at section 22A of the Evidence Act. It says that you can cross-examine, or you can, the admissions about the contents of the electronic record are allowed only if the genuineness is in question. So you cannot straight away go on the contents of the electronic record. You have to prove that this record is doubtful. You have to establish it, and then you can effectively cross-examine the witness in the court of law. And let me end with a very beautiful judgment that I will request you all to read of Justice Muralidhar in a case of Dharambir versus CBI. In this case, Justice Muralidhar has underlined the importance of a concept of a mirror image. Suppose if this is the hard drive, you as a lawyer of an accused is entitled to have a mirror image of this hard drive. Image of a hard drive? No, mirror image. Mirror image means that as each and every bit in this machine will be copied and will be given to you. This is called as a forensic image. Do not be satisfied with the ordinary image. It has to be a forensic certified image, because even if the data is deleted, suppose for example from this iPhone, in the mirror image that will be shown. You can discover the data which is deleted, and therefore mirror images are very important, and you have a right to obtain them under section 207 of CRPC. This is what there are judgments of the Supreme Court. The case of Dharambir talks about it, and therefore please always insist on the mirror image. Unless you have a mirror image, we also call it a clone copy or a forensic copy, you will not be able to effectively cross-examine a witness. With this, I will stop for the day, and I'll open the floor for the questions and answers if there are any.
Yeah. Who can get this certificate on section 65B, certificate in court?
Sorry, do I take, Vikashji, the questions in the chat box?
I'm taking those questions from the chat. Either you can take it from the top or from the bottom.
Whether can you? Sorry.
If the loan is applied online through an application.
Yes, I can see it. Yeah.
And accepted online by accepting the terms and conditions online, and verification was done through OTP. How the acceptance of the loan through OTP in application?
In these kind of cases, I have a chapter in my book. How do you prove these kind of cases? You can always take a snapshot. There are certain applications. For example, one of the application is duck capture. Now, how do you use these? These are all free softwares. They are all free applications, and you can use it yourself. You can take a snapshot of the page which indicates that you had that there was an acceptance of a loan. You can take a snapshot of the OTP. These will constitute the prints of the electronic record, so to say, under section 65B, and you can prove them in the court of law. There are many softwares which can help you to prove these kind of cases, or to prove how to capture the websites. Suppose if certain websites infringe your privacy, then there are certain good softwares that can capture the entire website. I have spoken about them at length in my book, that you can capture website, you can capture Facebooks, you can capture Facebook data, WhatsApp data, and these kind of applications where you accept the loans through the online platform.
Whether a certificate of section 65B Has to be in the pleading stage or at the evidence
No,
stage?
it can be at the evidence stage. In fact, the courts have said that at the stage of marking that document into the record, you have to have the certificate. It's not required to be in the pleadings. In a trap case, she recorded the voice of accused while demanding.
I can read the question so that those who have not opened
Yes.
the chat and they are on the YouTube, they will understand. In the trap case, recorded the voice of an accused while demanding bribe, and during the trial, they proved its identification by its CFSL report. Only voice of the accused, which was already marked as voice of accused, was sent to CFSL for identification. It was easy for the CFSL official to match the voice of the accused with the marked voice. What can be the defense counsel do?
Now this is called as there are ways and means to disprove the voice recording, and there are certain techniques. Again, as I told you at the cost of repetition, that I have dealt with this. This is a little technical part where this is called as a spectrography analysis, where if it's your case that it is not my voice, then under section 45 you can have your own voice recording sample recorded. You can send it for this analysis, and you can have your own expert step into the witness box and depose under section 22A, because you are now doubting the genuineness of electronic record, which is a condition in section 22A, and you can have your own witness examined. That is the only way you can disprove that this is not the voice of my client, but is being deliberately saddled on me.
Then how to cross-examine in the WhatsApp messages?
How to cross-examine the WhatsApp message?
Yeah.
No, this is as good as cross-examining anything. Cross-examining the email, cross-examining the WhatsApp. Again, there is, I have given around 12 to 14 illustrations. How to cross-examine WhatsApp is one of them. You will have to take a snapshot, or there is an option. If you right side, if you click on the right side, you can say you can always email the WhatsApp chat history, and you can take that email, you can print that, you can put 65B certificate elaborating the process, and you can put that into electronic into the evidence. That is as a proponent of the WhatsApp chat. If you want to cross-examine, then you will have to use the same data, and you will have to cross-examine as you regularly cross-examine proponent of any documentary evidence. There is no separate class for it.
This is family courts in Punjab and Haryana are taking a record of already exhibited CD, pen drive, mobile phones containing conversations and transactions between husband and wife on interim application of any party.
Sir, family
By
courts
stating
between the husband and wife
contained in this thing. That conversations are violation of right to privacy of wife. What is the remedy available?
So they are taking on record already exhibited CD, pen drive, mobile phones containing conversation and transactions between husband and wife on interim application of any party by stating bar contained in Neha versus pending is delivered by Pandit that conversation of violation of right of privacy of wife. No, I did not get the purport of a question. Are they taking it? Because if it is supposed to be a violation of right to privacy, then how can they take it? It's, I think, little self-contradictory.
No, if it's saying, can it be allowed? Because according to him, it is a right of violation of the privacy of.
No. No. You can't oppose it. Just to elaborate, there is a doctrine called as the fruits of poisonous tree, which is applicable in US. It means that if the source itself is illegal, if the tree roots are itself illegal, poisonous, then the fruit is bound to be poisonous. Therefore, the illegally acquired evidence becomes illegal. Now, this is the doctrine of fruits of poisonous tree. Indian Supreme Courts have specifically negated this doctrine, saying that this doctrine of fruits of poisonous tree does not apply in India, and therefore you cannot oppose these kind of evidences. They will go into the record, though they are illegally procured.
If the court denies the application to get CDR report of the complainant,
how many years the CDR is stored? Now this depends on case-to-case basis. There are few guidelines which I have made as an annexure to my book, which contemplate around 6 months, starting from 6 months to around 2 years, depending on the service provider, whether the service provider is a cellular company, whether the service provider is a government body, if it's a PSU. There are different guidelines available. But first thing you must do, whenever you come to know that this data is going to be of importance to me, you have to first send the notice of a preservation. Now I have given a format of notice of preservation in my book. It should contain that this data is important. You must identify the data. You must give him a specific notice that this data is going to be of use in the court of law, and please preserve it. Do not let it lapse because your internal guidelines say so. I am going to use it. In spite of it, if they destroy it, then IPC can be invoked for destruction of evidence. You can also draw, if the other side is an opponent, you can also draw an adverse inference under 114G of the Evidence Act for destruction of the data. Therefore, the first thing you must send is the preservation notice, because you are not very sure as to how many days they will preserve it. So to be on safer side. Yeah.
What are the steps to voice identification during cross-examination?
Sorry, what are the steps?
What are the steps to voice identification during cross-examination when audio is put by surprise?
No, I told you, voice identification is a technical chapter that I have dealt in my book, where we have to be little on the technical side to know the how to impeach the voice recording evidence. I'll, in fact, if it's possible, I would have just shown on the screen, but it's little technically difficult for me. In fact, the version that I in fact showcased on a screen is also not the final version of my book, because I cannot show it being the whole thing being copyrighted. But what I shown to you was a first rough draft of that had gone into making of the book. But if you look at the chapter number 6 of my book, it exclusively deals with how to deal with the voice recording. And as I told you, the only way you can do it is to by calling your own witness, by giving him a voice sample and cross-examining or examining him under section 22A. That is the only way to do it.
What are the laws regarding preparation of the transcript of audio? Can it be written by a producer of 65B certificate?
Obviously, it can. See, the transcript can be made by anyone who has heard it himself, because under section 60, it has to be by the person who has actually heard it or person who has actually seen it. So it can be by anyone. It can be by the producer of 65B. It may not be even by the producer of 65B, because 65B certification will be relating to the device. Transcript evidence will be separate evidence. Suppose if it is Vikashji's CCTV camera or his mobile, he records it, and I am doing the transcript, I will have to depose independently that I heard this myself and I have put this on paper. Vikashji's certificate will be about 65B saying that his mobile was in working condition and those conditions that we just saw. So there will be two certificates, one about the authenticity of the transcript that I myself heard it, and one by him vouching for the correctness of his device.
Yeah, I'm taking it from the YouTube. It says,
yes.
Is it necessary to move a separate application before trial court to lead the electronic evidence? And if it's so, then is it mandatory to provide the copy of those electronic evidence with the said application?
I got the first part of it, that is there a procedure to, is there an application required? No, there is no application required. If you look at the judgments of the Supreme Court, generally we are under wrong impression that for secondary evidence we have to file an application. I'm sorry, I'm talking of secondary evidence. I'll come to electronic as well. But even for secondary evidence, the Supreme Court has said you don't need to file a separate application as long as you are putting on record the foundational requirement of section 65 in your pleadings, in your evidence. You don't need to file a separate application for production of secondary evidence. Same logic applies to 65B. There is no need of any application. Suppose if this is the email, I want to put it on record, it can be with 65B. If it is not with 65B, I just put it along with my pleadings. At the time of framing of issues, I can simpliciter give 65B certificate along with what we here call pushes or with a covering letter. There is no application that is required to be filed.
A lot of people are asking about the book. The book is Electronic Evidence in the Manual.
Electronic evidence in the courtroom, a lawyer's manual. What I must tell you one thing, since reference is made to the book, there are almost now 3 prints have gone into the making, and it's currently, I think it's on the way to 4th reprint. So it will take around probably 2 to 3 days for them to come out with the revised edition of this. I think it's a 4th reprint isn't gone. So you will probably may have to wait for 2 to 3 days probably to get the 4th reprint that has gone. But this is a revised and updated one.
Yeah. The police verified the CDR of the mobile at the time of the accident using mobile. That is establishing the location of the accused.
Because I'm sorry, I'm not able to hear you properly. I think there is some.
Just read the last question by Srinivas.
Kasa. Yeah, the mobile verified thing. The police verified the CDR of mobile at the time of accident using mobile phone. That it is establishing that the location of accused. Okay, Jaimin Jewelry and all, I will maybe share with Vikashji once the judgments and once the session is over, I will share the link for these judgments, also obviously for my book. But just to answer the first question, police verified the CDR of mobile phone at the time of accident using mobile. That is it that establishing that the location of, frankly I'm not getting exactly what is meant.
Yeah. The question is a miss.
Yes, but yes, CDR always is used for establishing the location of the accused, and that is perfectly admissible to establish it. I don't see a problem using it.
The last question is, if there are two evidences, set of WhatsApp conversation and email response. So do I give 265B certificates or one is enough?
There are, sorry?
There are two evidences. One is on the WhatsApp chats and another is of email. So two certificates would be required or one?
Compulsory. This is a very good question. I must answer this in detail. Please always give separate certificates. You can't have just one certificate in the court of law, because 65B, the entire purport is that the nature, the treatment that you give to each kind of electronic evidence is always separate. You cannot mix them up. Putting that together creates a lot of trouble, and that is always undesirable, and it leads to very unforeseen consequences if you try to combine two kinds of electronic evidences. Never do that.
Yeah. So the last question by Pankaj Gupta. The video recorded on a mobile was shared as a CD with IO, and 65B was made too, which was included in the charge sheet. The CD...
Because I could not get it, sorry.
The video recorded on the mobile was shared on a CD with the IO, and 65B was too made, which was included in the charge sheet. However, the CD did not play in the courtroom for some technical reasons. Judge asked to prove the video copy in a pen drive. Does this need a section 65B certificate?
Does it? What was the last line? Does it
require need of section 65B certificate?
No. Yeah, this is a very good question. Again, I'll tell you something. I at the outset addressed this issue that there are many times an insistence is made that you must produce and must play all this. It is required just to establish the authenticity foundation, and you cannot technically run away from playing the video footage in the court of law if the court asks you to do it, because I refer to section 165, which gives power to the court to ask any or do anything that the court wants to ascertain for itself. But coming to section 65B, the words are very important: without further proof or production of the original. The moment 65B is given, you can tell the court that I have discharged my burden of proof, because the words are without further proof. Further is very important word. And without production of the original. Again, production is very important word. But having said that, let me tell you, friends, that whenever the court is insisting for original record, for the original device, just to ascertain the authenticity, please do not run away from it. Do not shy away from showing it. Court may then draw adverse inferences, because ultimately, if you know, there are judgments of the Supreme Court that if certain things have been requisitioned by the court and if not produced, the courts are well within their powers to draw adverse inferences. Therefore, let's not take that risk, but going by 65B, it is not required.
The last question, please do clarify as to who has the authority to give section 65B certificate.
No, this I said that the person in charge of the system, the person in charge of the machine will have to give this 65B certificate. If you refuses, if you try your best, if you invoke those sections that I just told you, in spite of that, if he doesn't come forward to give it, then you might have to then seek an exemption from producing it, or you can then give 65B certificate. Only thing you will do, you will not use the word in my knowledge, you will use the word in my belief, because you can't vouch for his system. You have to use the word belief. That is the only change that will be made to the certificate in that. But you will have to please mind that you will have to say that these are the attempts I made, these are the efforts I took, these are the endeavors I did, still I have not been able to get it. Therefore, by virtue of this paragraph of Anjul Pandit Rao Khotkar, I am claiming an exemption, and here is my 65B certificate. If you do that, I think enough is done, and then you can ask the court to exhibit that document into the record.
Okay. So thank you, Mr. Yuvraj. It was an enlightening session. Thank you, everyone. Stay safe, stay blessed. And tomorrow we have a session at 6 p.m. by Justice Mahavir Singh Chauhan, a former judge from Punjab Haryana High Court. Principles of Interpretation under the Contract Act. Do stay connected with us. Thank you, everyone.